Welcome to StarTalks powered by Advotalks. Today, we have with us our esteemed guest, Niyati Ahuja, who is an international dispute resolution expert. Let me give some brief introduction about Ms. Niyati. Ms. Niyati is a dual qualified legal practitioner in India and New York. She has experience with arbitrations arising under the rules of the United Nations Commission on International Trade Law, the body like ICC, which is International Chamber of Commerce, and ICSID, the International Center for Settlement of Investment Disputes, and the other one, which is like the London Court of International Arbitration. She has successfully represented many companies like mining, banking institutes, and individual investors in high stake disputes like the breach of fiduciary duties, the shareholder and joint venture disputes, the investment disputes involving the breach of stabilization and the concession agreements and stuff like that. She has also represented in many court proceedings in arbitration aid, matters seeking the discovery, the recognition, and the enforcement of the arbitral awards under the Federal Arbitration Act and the New York Convention, as well as cross border litigation proceedings. Apart from this, Ms. Niti is the founder of Indian Women in International Arbitration, and she acts as a facilitator for the Young ITA Mentorship Program and has served as a coach and arbitrator in several international moot court competitions. Niyati regularly contributes to the legal field through her publications on international arbitration, economic sanctions, and climate change legal framework. She has authored articles in reputable journals, including the Journal of Transnational Arbitration Institute and the American Review of International Arbitration. All of you know that we have brought an international arbitration expert onto the program today, and she has joined us in Star Talks to express her views on the evolving landscape of international arbitration, the trends, opportunities, and the challenges. I should admit that I'm quite excited to host her in StarTalks. With that, I want to warmly welcome you, Ms. Niyati, to our program StarTalks powered by Advotalks.
Thank you, Siraj, and thank you to Advotalks for the kind invitation and for the kind introduction that you just gave me. I am quite excited to be here and share my thoughts on all the questions that you have, and I hope it is helpful to the audience as well as all the participants.
Sure. So let's start a bit on trying to understand the fundamental aspects. For our viewers, can you explain the concept of international arbitration and the importance of international arbitration in today's globalized dynamic business environment?
Yes, of course. So for the purposes of this talk, we're going to talk only about international arbitration. There is, of course, domestic arbitration available. So just beginning to explain the concept of international arbitration. International arbitration is a process in which two or more parties to a dispute agree to have a neutral person or a panel reach a binding decision that settles their dispute based on previously agreed rules, norms, or terms. So the decision is usually binding on the parties and often on the basis of international law or the law that has been agreed by the parties. This process is often chosen as an alternative to traditional litigation that you must be familiar with in national courts. This is done mostly in international business transactions, as you asked what the importance is what the importance of international arbitration in today's globalized business environment is.
Yeah.
It is often chosen by international parties in cross-border disputes due to several reasons. Firstly, there is neutrality and impartiality. International arbitration provides a neutral forum for resolving disputes. So that would allow parties to avoid any potential bias or favoritism or the preconceived notion that there might be any potential bias in national courts while dealing with cross-border disputes. So they tend to choose international arbitration because it's a more neutral forum. Secondly, there is this huge advantage of confidentiality, especially when there is two international commercial parties involved. they really prefer to maintain confidentiality, which is often not available under traditional litigation. So arbitration offers flexibility in procedural matters, allowing parties to tailor the process to their specific needs and preferences. So there's a lot of party autonomy in international arbitration. Arbitration proceedings are usually confidential unless the parties agree not to make it confidential or agree to make it confidential. Preserving the privacy of sensitive commercial information and protecting business relationships. Usually parties who have a relationship want to make it work. So they don't want to go to a forum like a court where everything could be in public and that could impact their relationship. So that's another advantage. There's a lot of advantages. Another one, often you will hear parties choosing arbitration for the enforceability. Arbitral awards are generally easier to enforce across borders compared to court judgments, thanks to international conventions like the New York Convention, in short, but in long, New York Convention on the recognition and enforcement of foreign arbitral awards. This enhances the enforceability of dispute resolution outcomes in international transactions. Another really helpful advantage, but not the sole reason why parties would choose international arbitration, is the ability to get an expert or a technical or subject matter expert as their arbitrators. Arbitration allows parties to select arbitrators with expertise in relevant subject matters or industry. So for instance, mining or construction disputes require somebody to have an understanding of that industry to decide a dispute. So that really is an advantage to parties, where while if they go to traditional courts, if they adopt the court mechanism, they're not able to choose who the judge might be. Another one which has been debated for many, many years is the timeliness and efficiency of international arbitration. Arbitrations can often be efficient and expedient, and as compared to litigation, where courts have a very huge backlog of cases. Institutions are actually doing their part in making it a more efficient, expedient process by setting deadlines for different stages of the proceedings. So that is appreciated by parties as well as counsel, because they can reach a resolution quicker. And then going back to what we discussed, it's in today's globalized business environment, transactions often involve parties from different countries with diverse legal systems, cultural backgrounds. An international arbitration forum would provide a neutral and a better mechanism for resolving disputes arising from such transactions, and that would potentially mitigate the risks associated with cross-border commerce. So I think these are the main advantages. I'm sure there are more.
Yeah, thanks for bringing the quite difference between the domestic arbitration and the international arbitration, the way it is handled, and the role of the institutes that you have brought in the form of New York Convention and others, and also like how the specialization of the experts basically that are available as the practitioners in the international arbitration, all of those are adding to the particular benefits of the practice, as well as for the people involved in the overall this thing. Thanks for bringing multiple aspects of the cross border aspects and the cultural aspects. Those are like kind of, I definitely feel that those are certain challenges that any practitioner in the international arbitration must be going through. We have a lot of questions in the backlog, so let me move ahead and ask you a bit about understanding the role of these international institutes that you have mentioned. We have a lot of institutes, particularly when it comes to the international arbitration, like the you say ICC is there, like the International Chamber of Commerce. You have been working on various matters in association with the United Nations Commission on International Trade Law. I could also see that you're actively working on assignments pertaining to the London Court of International Arbitration. and the ICSID, for that matter, the International Center for Settlement of Investment Disputes. Can you suggest our viewers, like, what are the rules and procedures that are followed in these different bodies pertaining to the international arbitration, Niyati?
Sure. So arbitration can either be institutional, and that's when ICC, ICSID, LCIA, the Singapore International Arbitration Center, the SIAC, the HKIAC. There's so many more, but there's a lot of institutions that come into play when it is an institutional arbitration. It could also be ad hoc arbitration. That is when the parties have decided to, for instance, opt for the UNCITRAL rules, but have not decided which institution will, or no institution will be administering the dispute itself. The terms of the contract usually will dictate what kind of arbitration it is, if it is institutional or ad hoc. If the parties have agreed to have an arbitration institution administered, like the ones that I just mentioned, administer the dispute, it is an institutional arbitration. Otherwise, it is an ad hoc arbitration. So most of the major international arbitration institutions like SIAC, the ICC, ICSID, LCIA, they play a significant role in administering arbitration proceedings and provide essential services to parties involved in disputes. Their roles typically include, firstly, of course, administering the arbitration proceedings. They administer the arbitration proceedings according to their rules and procedures. So every institution has their rules. So if you are choosing to have your dispute be administered by, for instance, the ICC or LCIA, you will be their rules will be applicable to your dispute. So these institutions would facilitate the appointment of arbitrators. They would manage communication between parties and arbitrators, or party representatives and arbitrators, to be precise, and oversee the arbitration process to ensure its efficiency and fairness. Another big thing that they do is help with the appointment of arbitrators when parties are unable to agree on either the method of appointment or the arbitrator itself. Some institutions maintain lists of qualified arbitrators and appoint them based on the parties' preferences or agreement. Thirdly, they provide support and guidance to the parties throughout the arbitration process. They help with procedural matters such as setting hearing dates, managing document exchange, even with virtual platforms, because we are seeing more virtual hearings since the pandemic. They also, one of the most important things they do is they develop their arbitration rules and procedures, and they have been doing a great job at adapting to the changing legal and commercial environments, which would often include the climate change disputes, or it could include having more younger advocates or diverse advocates as appointed as arbitrators. So they often consult with arbitration practitioners, academics, and other stakeholders to ensure that their rules remain relevant as compared to the current environment. They offer hearing facilities, services like that. They, of course, one of the main objectives is they promote arbitration, and of course they engage with the parties, as well as companies, businesses, practitioners, policymakers, about the benefits of arbitration and developments in the field. They also, this comes within what I had earlier mentioned, they try to ensure there is the quality and integrity of the proceedings, and that everything is fair. And they may also have codes of conduct for arbitrators so that they can adhere to the best practices for the continuation of the arbitration proceedings.
Great, great. I think like there is a wide, scope of what the proceedings about the arbitration proceedings, administration, be it the appointment of the arbitrators, as you mentioned, and there are a lot of rules and procedures on the development of the arbitration rules. Basically, the institutes also play a major role. That I could get that. Thanks for bringing those aspects of the quality and integrity, ensured through the rules and procedures that are coming up from the institutes. I was quite, trying to understand the role of arbitrator when you have mentioned about, the way it is kind of, administered for the appointment and stuff through the institute. What is the role of arbitrator in an international arbitration process, and how it is different, when compared to the domestic process? And then how the evaluation of the evidence and the determination of the damage is done typically in an international arbitration case?
Very interesting question. So, of course, as you would predict, an arbitrator plays a very crucial role as an impartial third party responsible for resolving disputes, especially because their award is binding on the parties. So they perform a plethora of their role is quite wide. They facilitate the arbitration process. They manage the procedural matters, the procedural timetable. They conduct the case management conferences, ensure that the arbitration progresses efficiently. They evaluate evidence. Of course, parties are able to, with their pleadings, submit evidence for evaluation of the arbitrators, supporting evidence, which helps them prove their case, of course. So this could include the evidence could include witness testimony, documents, that is the exhibits, expert reports, and other form of evidence. So the arbitrator would evaluate this from both sides if the parties do decide to submit these kinds of additional documents in addition to the pleadings. They, as you mentioned, they have a great role in determining the damages. One of the main things that parties want at the end of the arbitration proceeding is to get the damages, especially the claimants. After evaluating the evidence, arbitrators would make determination on liability and would calculate damages. Oftentimes, as I mentioned, parties tend to submit damages report and sometimes also expert reports on very specific matters. For instance, if there's a technical issue that is under evaluation. So they determine, going back to your question, they determine damages by looking at these two damages reports submitted by the parties. They sometimes also appoint an independent damages expert if required. I have not been in a proceeding where that was done, but that is their basis of determining the damages. And then, of course, the last one is they issue the award. That is the final and binding decision resolving the dispute. This is known as the arbitral award. And I think these are the four main duties or roles that the arbitrator plays in the international arbitration proceeding.
Great, great. I think like a lot of aspects have been brought in, where about the determination. Basically, I think like the evaluation of the evidence along with the determination of the arbitration awards is something, and the issuing award is the other aspect that you have brought in. And I think I'm sure that this discussion is getting more informative and kind of insightful, that I should say at this particular moment. Thanks for bringing that, and let me move ahead, and we'll try to understand from you some of the key issues that commonly arise in the international arbitration, especially like the jurisdictional challenges, maybe the awards enforcement aspect and stuff like this. So, what are these common challenges that frequently one can kind of face through?
So I think there are three major challenges or issues that are faced or I have come across in international arbitration proceedings. One, as you mentioned, is jurisdictional challenges. Parties may dispute the arbitrator's jurisdiction to hear the case, often based on the arbitration agreement scope or validity. And of course, the claimant who submits the request for arbitration or initiates the arbitration would assert that it falls within the jurisdiction of the arbitrator, and the opposing party would argue otherwise. So there is often this challenge or issue that comes up in international arbitration proceedings. Secondly, choice of law, determining which law governs the arbitration agreement and substantive issues can be contentious, especially when it involves parties from different legal systems and they have not agreed in their arbitration agreement or the arbitration clause in their contract or a treaty. What would be the choice of law? That's something I've seen. Thirdly would be the enforcement of awards, enforcing arbitral awards, even though you're going to a country which is a signatory to the New York Convention. It might be difficult in different jurisdictions due to variations in national laws and enforcement mechanisms, and also the exceptions that lie to within the New York Convention to enforcement of awards. So I think these are the three major issues that I've come across. I mean, there's some minor issues we always face, but these three, and maybe sometimes due process challenges.
Mhm. Okay. Thanks for bringing out those challenges that that as an industry we are facing. And let me move ahead. And I know I am reaching out to the better person for asking this question. And you have been recently nominated for the Global Arbitrations Review Award, like for this year 2024. Congratulations for that. And I would decide that the category that you represented is the equal representation in arbitration. That's something that I wanted to bring, and I wanted to understand from you, why is diversity so important in the field, especially like international arbitration, Niyati?
Sure. First of all, thank you so much. Not me, but my organization, the organization that I founded, Indian Women in International Arbitration. It was nominated by the Global Arbitration Review Awards this year. I'm very, very happy to be nominated.
Yeah.
And thank you for the mention. So moving on, why this organization was founded is the same answer as why diversity is important in international arbitration. There is a lot of diverse candidates there who are doing excellent work in this field, and there is underrepresentation. Um, and I believe institutions are working towards getting a parity of appointments and things like that, but it still seems to be lacking because diversity is in race, in age, in a lot of different aspects. Why it is important? It is important because it would ensure different perspectives, expertise, and cultural sensitivities are being considered, which would enhance, in my opinion, the fairness and legitimacy of the process. Diverse arbitrators can contribute to better decision making, reflect the global nature of disputes, and promote confidence in the arbitration system. When parties see that somebody who looks like them or is on the arbitration tribunal or is active in the field, it promotes confidence in the international arbitration field on the whole. So I think it's very important, and we're all doing our part. It is
Yeah.
much better than it used to be, but it continues to be an area which where diverse candidates are still underrepresented.
Great. I think like I should admit with what you have said, like given the global nature that is reflecting in the international arbitration as a practice, I think this promotes the confidence if there are a diverse, arbitrators who can contribute to the decision making and stuff, and bringing a lot of confidence in the arbitration system as such in whole. Thanks for that, Neeti. Let's move to the final question of today's episode. In your opinion, what are some of the current trends that are happening and disrupting in the international arbitration as such?
Well, there is several. International arbitration is definitely a booming field. People and companies are choosing international arbitration as the means of resolving their disputes. It's also a difficult question because I'll try to keep it short. I think one of the main trends or things that I'm seeing now is more technological integration. Has been and continues to be an increased use of technology for virtual hearings, electronic evidence management, and to just generally streamline the arbitration process. I think the pandemic kickstarted that process, and I'm very happy we're moving towards adopting technology rather than being scared of it. Second, I would say is we are seeing more ESG, the environment and social responsibility related disputes, as well as climate change related disputes. Many countries are trying to comply with the Paris Agreement, and that has led to some newer disputes because these states have adopted national laws or changed their national laws to be compatible with with their obligations under the Paris Agreement. So that's something we are seeing right now, and I think we'll continue to see more of that. We are seeing the growing importance of the Asia Pacific region, which I'm very happy to see. The Asia Pacific region is emerging as a key hub for international arbitration. As you are probably seeing all around you, there is economic growth, there is infrastructure development, increased cross-border investment, both and even if you take the example of India, both incoming and outgoing, there's more investments. So arbitration institutions in this region are also gaining prominence. For instance, Singapore International Arbitration Center is one of the top 3 preferred institutions right now. And then we are seeing more third-party funding, and there's more acceptability and regulation of third-party funding arrangements, which allows parties who might not be able to finance arbitration proceedings to still obtain this third-party funding and move forward with that.
Yeah.
I think those are the 4 main trends or things that I'm seeing now. Maybe an additional one would be crypto disputes. We are seeing a rise in those. But yeah, I promise to keep it short. So those, I think, are the main trends that we are seeing now.
Right, rightly pointed out. I think like the growing importance of the APAC region, as you mentioned, as well as the integration of the information technology in the form of usages of digital documentation, as well as like the evidence management and stuff like that. I think like a lot of artificial intelligence is also booming up into multiple industries, and international arbitration is not an exception. Thanks for bringing these aspects of current trends of the international arbitration. Niyati, that brings us to the end of this great insightful conversation, and thanks for helping us and our audience to understand the various aspects of the international arbitration. And we appreciate you taking out time for this conversation at StarTalks. Thanks a lot again from the Advotalks.
Thank you so much, Siraj. Thank you for inviting me in, and it was an excellent discussion. Thank you for the very well thought out questions that you put forth. And I hope that whatever we discussed is going to be helpful to your audience and yourself. And I thank you again for inviting me here.
Okay. So, viewers, that's for today. And I'm your host, Siraj, in this episode with Niyati Ahuja, which brought a lot of insights on the international arbitration practices. We hope this conversation was knowledgeable. And for more updates and information on legal concepts, please visit our website, www.advotalks.com. And don't forget to like, share, and subscribe to our YouTube channel, Advotalks.